Introduce myself. I am a lawyer here in Pocatello. I've been here for 40 years, since 1975. And I have my own firm. I practiced in the Racine firm for 23 years, and then Reed Larson and I went out on our own, and we've been, in fact, today we celebrated our 17th year of practice. So.
Good.
Yeah, well, thank you, thank you. It was Founders Day at my office, so that means that everybody brings nice food and we have a great time. So, and we also today signed the lease between the church and the auditorium district so that we can build the auditorium, and that'll be going up shortly. So it was a big day at my office, and then I get to do this. So, no, this is fun for me, and I hope it's going to be informative to you. Just to give you a little bit more background about me, my wife, Jane, is a longtime member of this church. When we moved here in 1975, she was down at Grace Lutheran, which at that time was on Center Street, and immediately became a member. She's a lifelong Lutheran, grew up in the faith, and I wasn't so good about following. I had to be drugged along, and fortunately I had a mother-in-law who we fondly say loved me into becoming a Lutheran and a Christian. So last year I was baptized about this time and became a member of the church. And so anyway, I feel like I'm a member because I've been around it for so long and tried to help people out here when they had legal problems. So, you know, my practice is really more, I'm a trial lawyer, so I go to court and do those sorts of things, and we fight with people all the time and stuff. Wills and trusts and advance directives are, you know, one of those things that I've never specialized in, but you know, now that I'm 65 years old, I'm finding that it's a little more real. And so I've become a little more interested in it, of course. I just want to tell you, I think I have some cards here. I'll hand out cards. You're welcome to call me at any time. I love talking to people about their needs and stuff like that. But there are a lot of lawyers here in Pocatello which probably specialize in this sort of thing. And you know, they for years they've kind of honed their skills to be what they call elder lawyers, which I hate that word, but lawyers for people who are in need of wills and trusts and all of those things. So there's also a service through the Idaho State Bar Association in Boise. If anybody ever needs a lawyer about anything, not just this, but for any purpose at all, and you don't really know who to call the State Bar Association, because they keep a list of people and their specialties, and people kind of sign up on this, and they're kind of vetted. So I'm not saying that the bar necessarily vouches for them, but they're on a list, and they're pretty well recognized because we kind of police ourselves as being specialists in a variety of fields. So it's a good resource. I've kind of found that everybody used to advertise in the Yellow Pages. That's a waste. Nobody looks at the Yellow Pages for a lawyer, let me tell you. They go on the internet and they look it up on the internet. And the internet's a tricky place for guys like me, and probably for most of you. You don't know whether you're getting good information when you get on there or not. So I think, you know, sometimes just slow down, call the Bar Association, say, I need a lawyer, this is the area that I need, and they can give you some good information about people to contact. So we're here today to talk about advance directives. And my purpose in coming here and talking to you is that I was asked to do it, first of all. That's a nice thing. But I think that this is the thing that people, it's just natural. We don't want to pay attention to this. Why do you want a living will? Why do you want to think about that sort of thing? It's one of those things that you put on the shelf if anybody talks to you about it, and you say, I'll think about that next week. Well, one day you're going to go through the doors at the hospital and you're going to need this. And that's not the time to start trying to think through, what does this mean? What am I doing? How am I going to handle these things? So the purpose in coming here is give you some information, let you start thinking about it, and really, you need to put this on your agenda and get it done. So how many people here right now have a power of attorney? Okay, not very many. Healthcare power of attorney, okay? A living will, do you have a living will? Okay, and what about a will? I assume you have a will also. So trusts,
Yeah.
do you have trust, things of that nature? Okay, so there, you know, you guys know what I'm talking about. The thing that happens is we have those. Do you know what it means? Have you really thought about it? Have you given it some thought? Have you talked to pastor about it? Have you talked to your lawyer about it? Have you talked to your doctor about it? These are very serious decisions. You're talking about end-of-life decisions, how things are going to go. And you know, people that come into my office, sometimes they look like deer caught in the headlights when you start talking about these things. It's the last thing they want to think about, and they want to be a little macho, so they say, you know, I don't want anything. I don't want anything. That's the one I want. Well, they're telling it, I think, to impress me that that's what they want. Well, they haven't really thought it through. You need to think these things through. These are difficult issues, both, I think, morally and legally and personally. I think probably all of you have read that California recently passed legislation that allowed assisted suicides. Well, that's a big issue, you know, as to whether you can do it. I think the governor is talking about vetoing that legislation or not signing it because he has moral problems with it. And so, you know, this is a little bit along on the same lines. Idaho does not recognize euthanasia, assisted suicide, any of those things. It's totally against that. We don't have a law that allows that. But in 2006, we passed some pretty progressive legislation. And that legislation allows people to make choices about whether they get medical care at the end of their life or they don't get medical care. And it's done with the intent, I think, of providing people with a certain amount of dignity in their last days. And that's when most of these things take place. And unfortunately, most of these things take place at a time when you no longer have the ability or the power to verbalize what you want. You've done that in advance, and people are going to rely on that. So, advanced directives are a durable power of attorney for health care, and a living will, and physicians' orders for scope of treatment, POST. And we're going to have somebody that knows more about POST talk about that in a few minutes. I just want you to know that that's there. It used to be a do not resuscitate order. Now they've expanded that, and I'll let people that know about that talk about it in more detail. So let's talk about some of these things. The durable power of attorney for healthcare, just in general, what does this allow? In recent years, we've had some federal legislation called HIPAA. I can't remember what that acronym stands for, but it protects the privacy of healthcare records and the like. It makes it much more difficult for people to get access to other people's medical records. So the durable power of attorney for healthcare kind of came out as a result of that, because hospitals just wouldn't give everybody, you know, they may not give your children your medical records unless they have something on file which allows them to do that. Spouses haven't been the problem as much, but you know, sometimes people don't have a spouse that's either competent or functional, and so, you know, maybe there's a family friend or a relative or something like that that they've been relying on that. If they don't have something in writing giving them the authority to access their medical records, doctors aren't going to talk to them. They're not going to be able to call up and find out what their condition is. I don't know how many of you have tried to call up to the hospital and say, hey, how's my friend doing? Well, they aren't going to tell you how your friend is doing. It used to be that we could do that. We could call up and they'd say, oh yeah, they've come out of intensive care and they're on the main floor. They don't tell you that kind of information now unless you have one of these. So this statute that was passed in 2006 actually sets up some priorities, and we'll talk about those in a few minutes. But the main thing that you have to think about a durable power of attorney for health care is you're giving somebody else the authority to access your medical records, and I think more importantly, you're giving them the authority to make some decisions for you. Are you going to receive medical care? What kind of medical care are you going to receive? Are you going to have an operation, or are you not going to have an operation? Is medical care going to be withheld? Are you going to leave the hospital and go home against doctor's orders? So you're giving somebody the authority to do that. Now, that's a big, big decision. You don't take that lightly. You don't give it to somebody that you haven't talked to, first of all. And I think, you have to make certain that that person is on the same page with you. And it usually would be your spouse, but let me tell you, by the time we get to our age, our spouse may not be competent or able to make those sorts of decisions. And I think the most important thing I can tell you about a healthcare power of attorney, everybody's going to give it to their spouse. I shouldn't say everybody, but I'd say in 95% of the cases when people come into my office, they give their spouse the healthcare power of attorney. And until recently, I didn't really think so much about having alternate agents until I've started seeing some of my friends who are a little bit older than I, and their spouse was unable to make these decisions. Just the fact that their spouse was in the hospital, serious condition, they were powerless. I mean, they just shut down. They weren't able to make the decision. And so you need to think about that, whether it's a son, a daughter, a good friend, whoever it is, there needs to be at least one alternate in there so that if that happens, you've got somebody that they can go to when it happens. The next advanced directive that I'm going to talk about is the living will. So basically, this provides some instructions to your healthcare providers and frankly to your family. I think, the situations that we've heard over the years that I think bring on the most publicity are a spouse that's been in an automobile accident, they're comatose, they're on ventilators and the like, and they're being basically kept alive artificially, and nobody has the power to withdraw the medical treatment. Now, that's kind of where living wills came about, is because some of these cases became pretty highly publicized. It was a very difficult thing for the family to make these decisions. It was very difficult to, I know people don't have a lot of sympathy for judges and lawyers and courtrooms, but that's where it ended up. And now they have to try to make that decision for people. It's not a very comfortable situation. We don't have any great powers to make good decisions in that situation, and so they struggled with it. So as a result, we came up with the living will. It gives some instructions to people about what your wishes are when you come to that point in your life that you are near death and you can no longer communicate your wishes. That's when this generally comes into being. So I really want to focus on the living will first. So I think this is the one that is most confusing to people that come into my office. And I've many years ago decided this is not something that you should just discuss with me. um, I'm not really the person, I mean, I can tell you legally what all this means and that you have a right to do it, but I'm not the person that you ought to be consulting with about that. I'm the person that ought to be providing you with the legal forms and the like to do it. The people you ought to be discussing this with is yourself. I mean, you ought to have a discussion with yourself internally. What do I want in this situation? You need to have that discussion with your spouse or your close family members. What do we want to do if this happens? What do we want to do if it happens to any of us? Because you probably, if you start talking about this, you're going to talk about this in the context of everybody needs this living will. I mean, even young people get in these situations. You know, tragic accidents happen all the time, and there's people that are left in this sort of a situation. Somebody has to make a decision as to whether they're going to receive treatment or they're not going to receive treatment. So everybody should be considering that. And I think if you're people of faith, you need to be talking to your pastor about this, or somebody in the church, and make sure that you're thinking through that aspect of your life, because it's an important part of your life. And our hope, I think, for all of us is that we pass away in a dignified manner and we do it faithfully. And so you have to think about those things, because some of these things, even though we don't recognize assisted suicide, some of these decisions come very close to it, in my opinion. I'm not saying it's right, wrong, or indifferent, but I think some people would think so. So I think we have to think about that. So when does this come into place? Do you see the nice nurse?
Yeah, that's very nice. Thank you. Thank you.
So the first scenario where a living will comes into place is that if a person has an incurable or irreversible injury, disease, illness, or condition, in other words, it's terminal. The legislature saw fit to define this. And I don't know whether they made it more complicated or easier, but this is how the legislature in the state of Idaho defined it. Terminal condition means an incurable or irreversible condition which, without the administration of life-sustaining procedures, will, in the opinion of a physician, result in death if it runs its usual course. Now, you get into the form itself, and it says that, okay, but it also goes to, it brings in the medical profession, and that's why I say I think you have to have this discussion with your doctor, because I think doctors all look at this a little bit differently. So the medical doctor, before this is determined that it's terminal and incurable, they have to certify that it is in fact terminal. Artificial life-sustaining procedures would only prolong life artificially, and death is imminent regardless. Okay? So let's say that they've certified that. What does that mean? Well, it doesn't mean that they just kill you at that point. Now, there's some choices. You're in that condition. Before I get into some of that, I want to talk to you about the other situation, and that is that you've been diagnosed as being in a persistent vegetative state. So remember, there's kind of two situations here. The one where somebody becomes comatose, vegetative state, or they've got an incurable illness that's going to result in their death. And this comes into play where you can't communicate any longer. Because if you can communicate, you can tell them what you want in this situation. So this living will doesn't apply. This is, I mean, just think of it this way. You're caught in your body, you hear what they're discussing out there, you can't communicate what you want. And that's when this comes into play. I think that's a scary situation. That's why I'm urging you to really think this through so that you understand what you've done when you find it. Now, irreversible is also, or a persistent vegetative state is also defined by the Idaho State Legislature. And they say this: it means an irreversible state that has been medically confirmed by a neurological specialist who is an expert in the examination of non-responsive individuals, in which the person has intact brainstem function but no higher cortical function and no awareness of self or environment. I mean, I sort of understand what that is, but, you know, talk about legalese. I mean, we've taken a medical condition, defined it in a book, and in some ways I think it makes it a lot more difficult. But so as I said, okay, you've been determined that you're in one of these conditions, and obviously, I mean, looking at it, we would all say you're in a very serious stage. You're at the end of your life. Now, what's going to happen? So the choices that you have is several, and this is really what you're doing by your living will. You're making some decisions in advance. You can direct that all medical treatment, care, and procedures necessary to restore your health and sustain your life be provided to you. You can make that decision. Well, that's one of the choices. You don't withhold nutrition. You don't withhold hydration. You hope for the very best that this person is going to recover. Now, most doctors, I think, will tell you that if you're in scenario number 2, where there's no higher cortical function and no awareness of self or environment, you're not going to recover from that. But this is the choice that you make. You can choose that I'm going to be placed on hydration, I'm going to be placed on nutrition. Now, you may pass away anyway, but you may not. You may stay for a long time in that condition. Those are the cases that we've all heard about, where people have lived for years on ventilators and other medical devices. I mean, medical treatment has come a long way in our years, and we can sustain life. You can also direct that all medical treatment be withdrawn. I don't want anything. If I'm at that stage, I want you to let me pass. So withhold nutrition, withhold hydration, and, you know, the Lord will take me when He does. That's basically the decision you can make. Now, there are choices within that. You can say, accept nutrition or accept hydration. You can make your choice between that. The doctor has to make a choice that you would die from the disease or the underlying condition rather than malnutrition or dehydration. I say that's a fine line, but that's the scenario that we've set up for people. So you have all of those. There is an exception for pregnancy. If somebody is pregnant, then there are exceptions to that, I think, so that the child can go to term and be born before any of these take place. Now, when do you make these and how do you make this? Now that you kind of understand. I mean, have I explained the choices that you have? Do you sort of understand what the choices are? Go ahead, yeah.
Gary, I'm one of those that, even with the nutrition and hydration, I know when we did my parents, there's also a pain management step in there medically, so that even if you're withholding hydration and nutrition, you can accept pain meds so that you're not dying.
Am I right? That's
Pain.
more comes in the post, the
we'll
physician's
talk about that.
orders
Okay.
for treatment, because that's kind of where that piece comes in. But you're absolutely right. That is something. This is a multifaceted, complicated situation. So my purpose here is not to try to tell you exactly what all of this is. I want you just to understand, you know, these are the choices that you have. And I highly recommend that all of you within the next few days or weeks, execute one of these. You need it. You don't want to leave this up to somebody else to make these decisions later on. Now, how do you do that? Do you have to go to a lawyer? No. This form is actually set up by this legislation that was passed in 2006. You can go to the Secretary of the Attorney General's website, and that's you just Google the Idaho State Attorney General, and you can go right to the website. You can type in Idaho Attorney General Living Will or Durable Power of Attorney for Health Care. It'll take you right to the form. These forms can be printed right in your own home, and you can sign it. Now, what do you do with them once you sign them? Well, you don't put it in the drawer. And, you know, I can tell you, in years past, I've seen people bundle all of these up, put them in an envelope, put them in their safe deposit box, and nobody knows that they're even there. Well, it's not going to do you any good, okay? Now, that's one thing that I applaud our legislature for doing, is that they set up a registry. You can actually record these with the Idaho, I want to say it's the Secretary of State, but this information is in the website as to where you go to register. I think they charge you $10 to do this. And you register it now, healthcare providers can access that. They can find out what it is, because you may have been in an automobile accident and all they know is your name. They don't know you. You're up in Coeur d'Alene passing through at the time you get in this accident. You don't know where the papers are. You can't communicate. They can access this. Now they have what your directives are. And you know, that happens sometimes. And I think for $10 it's easy to do. Yes?
Do you have to have a notary or anything? I mean, do they just assume it's you on the website? That's a little scary thing for me to think I'm typing in here and it, you know, or somebody would have access to. I guess I'm kind of confused on that. You
Well,
just submit it and
to tell you
they
the
believe
truth,
you?
to tell you the truth, let me just see here whether there is. There is a password, it's password
Okay,
protected
okay,
and stuff.
okay.
And so if I remember right, you get well, in fact it says, you get a wallet-sized card, which you would put in your wallet
Okay.
and have with you. And so, you know, presumably they go through your wallet and see it.
Because there is
so.
another Karen A. Swallow in this town.
Well, that's a good point. And I'm glad you brought that up, because I actually didn't even think about that.
Yeah.
But fortunately, the statute says, and when you
Okay.
said that, I thought, yeah, they aren't going to allow just anybody to get on. I mean, I'm not going to be able to just get on your
Correct, I
on the
understand all
website
that,
and
but
get
that's
that.
what I was
But
saying.
that's how it's going to get it. You're going to have a card,
Okay.
and it'll give the password and all that
You don't want
information
Karen
so that they can
Swallows.
access.
When somebody accesses
I
that
get accused
medically.
of doing a lot of the things that she does, and she's not a nice person, but it's okay.
You gotta go by more than the A.
What about
Yes.
other states? Is this, you know, because if you travel Utah, Arizona, New York,
I can't tell you what another state would do. I think that
Okay.
if you have that card, they could access it. I don't know whether every state recognizes this same thing. I mean, there may be some states that don't recognize the directives of a living will. I'm not aware of any that don't, but if you have the wallet-sized card, they're going to actually be able to access it and use it for whatever purposes they do in that state. But you know, that's the thing. Laws from one state to another vary a lot. So.
Sorry we got you out here.
No, that's why I'm hoping that there will be a few questions, because there isn't enough information to tie up the whole, time here. I think the other thing that is important to know about this is that you have to be mentally competent to execute one of these. And so that's why I say, people need to do this in advance, because if you're in the hospital and you're confused because you're under medication and things like that, you may not be competent to sign one of these. I can tell you, am I right, that when you go through the hospital door, they're gonna wanna know, do you have one of these?
Yeah.
And if you haven't, here it is. What do you wanna do? It's not the time to be trying to figure this out. It's a little bit more complicated than that, so. But they have to determine, just like I as a lawyer have to determine if somebody signs something like this, that you're competent to do it. And unfortunately, sometimes we put these things off until, we have a stroke or some medical condition and we're no longer competent to do these sorts of things. And I'll talk about that a little bit later as to, why it's a wise idea to do some of these things. As I said, we'll talk about the post forms pretty soon. So the durable power of attorney for healthcare, as I said, competent people can sign these.
And you don't need a lawyer to do that one?
You do not. I'll tell you, the healthcare power of attorney, the only thing that I question a little bit about the form that comes from the Attorney General is it's all one form. You have the living will on it, plus the healthcare power of attorney. I kind of object to that. I think it's better to have those as two separate documents. It just makes more sense to me. The healthcare power of attorney, that's something that you definitely your doctor needs to be aware of that. Your general practitioner, the guy that's going to be treating you in the hospital, needs to be aware of what your wishes are. The healthcare power of attorney is a little different. I mean, that isn't so important that he have that. It's important that your family members have it, so that when something happens, when they go to the hospital, they've got that form, and they can now start making decisions for you if you're unable to make those decisions. So I would just separate the forms, but if you go on the website, that's what you're going to get. Doesn't mean that you have to fill out the top part of it. You can put an X through it for that matter. But so don't get worried about that. You don't have to spend a lot of money for these things. That's one thing. Even if you go to a lawyer, I mean, these are forms that you can pull up and do. So I mean, you shouldn't get more than a nominal charge for these sorts of things.
And you don't have to have somebody else sign it or witness it?
I get confused about this because some of these have to be executed like a will, and I can't remember which one it is. I handed some forms out to everybody.
Yeah.
I think the durable power of healthcare, they recommend, and the state of Idaho does not require a witness, but they recommend that you do have, it doesn't need to be notarized, but they do recommend that you have a witness, but it's not, you don't have to have one, but they do recommend that you
I
have.
should go
but a
get one
witness
of those
is needed.
forms. I need to look at that.